Hi, everyone, and thanks for joining us today for Jennifer Strauss and Associates in our COVID-19 and new federal government contractor requirements webinar, live from Washington, D.C. We work with U.S. federal government contractors, including product, service, and software firms. Our services range from market analysis reports to contract vehicles and compliance. There's more information available on our website. We've launched another webinar series called the GOVCON Q&A Cafe. This is a live webinar series held each month and take place on the second Friday of every month in 2021 at 12 p.m. Eastern. We have assembled a group of 4 panelists who are subject matter experts on specific federal contracting topics. The panelists will make a short presentation about the topics listed here on your screen, and then take your live questions about that topic. Our panelists include attorneys, consultants, and other industry professionals. You can sign up on our website under the Q&A Cafe tab. Sponsorships are available. Next month, we will be covering set-asides with Anna, Eric, Sai, and Tim. In November, we get into pricing with Michael, Marcia, Tracy, and Jeff. And lastly, in December, our speakers Shirley, Joshua, Kate, and Brad will present on M&A. There is a discount code available, which is DFARS, to save $15 and bring your cost down to $20. And now to introduce you to today's speaker, we have Jody Reed. Welcome, Jody. We're so glad to have you here with us today, and I'll turn the floor over to you.
Good morning, everyone. I am an attorney here in the Washington, D.C. area, Reston, Virginia, to be exact. McMahon, Welch & Learned is a very small law firm, although we've just gone from 6 attorneys to 8. We specializing in helping small, medium-sized businesses in the broad range of government contracting issues, including new and emerging issues such as this new federal government contract requirements regarding COVID-19 and getting vaccinated. I'm going to say right now, I just blanked out. So we're just going to go to I know what I was going to say. I do have to give the disclaimer. I am providing you information. I am not providing you legal advice. If you want legal advice, you actually have to hire us, and we have to do other formal things for you to hire us. So this is purely an informational presentation only, and you cannot rely on anything that I say as being legal advice. And with that disclaimer, because well, attorneys always have disclaimers, let's go to the next slide. So basically, on September 9th, President Biden issued an executive order. It was Executive Order 14042, ensuring adequate COVID safety protocols for federal contractors. And in this executive order, he directed agencies to do certain things. And he also directed the FAR councils to do certain things. One of the first things that was required was that an organization called the Safer Federal Workforce Task Force had to issue guidance by September 24th, 2021, on how the federal government wanted to handle and require their contractors to be vaccinated. And I'm sure there are many people that the first comment will be, well, it's not constitutional, and a lot of other things. I've heard everything that you can imagine over the last, quite frankly, almost just a little over a week as to why this is not allowed. But fundamentally, much like every other social program, the federal government, when it buys stuff, can decide its requirements and what it requires its contractors to do. So while there is some speculation that there will be some litigation on this subject, the belief across the legal industry to people that I have talked to is that, yes, the government can do this, much like they've mandated things in your contracts that equal opportunity, no discrimination, hire more veterans. All of those social economic programs have certainly passed any kind of judicial scrutiny, and we believe this one will too. So basically, what the executive order said was it had to include a clause in something that's called covered contracts and contract-like instruments that'll be collectively referred to as contracts, and we'll define what all those include in subsequent slides, that specifies for the duration of the contract that the contractor and its subcontractors, by the way, at all tiers, comply with all guidance for contractor or subcontractor workplace locations published by the Safer Federal Workplace Task Force. As I indicated, the executive order provided timelines. The first one was the task order guidance to be issued September 24th. It was issued. And that is what we're going to be talking about today. The proposed FAR clause is actually due out in 2 days. And what happens with the FAR clause, because the FAR clause has to still go through the standard regulatory review cycle, it will come into being, but then agencies do not have to actually, it doesn't become part of the regulation until it's gone through the review cycle, and that normally is somewhat of a 20 to 30-day cycle, depending upon what exceptions they might use. So the clause is going to be in place October 8th. I see no reason why they're not going to do this. And you can expect, even though the clause is not fully part of the FAR, it is supposed to be included in contracts starting October 15th. And again, even if it's not in the FAR fully, the clause can be put into contracts because, once again, the government can decide what goes into their contract. And covered contractors' employees must be fully vaccinated by December 8th. And we'll talk about how these dates kind of move down on certain things. Next slide. So what does all of the executive order apply to? It applies to new contracts, new contract-like instruments, extensions or renewals of existing contracts, exercise of options. All of them are considered to be covered contracts. Next slide. It is expressly not applicable to grants, contracts with Indian tribes that are subject to Public Law 93-638, contracts or subcontracts below the simplified acquisition threshold, and we'll talk a little bit more about that in a second. It doesn't apply to employees who perform work outside the United States or its outlying areas, and subcontracts solely for products. So this latter one seems to be a little bit not clear in any of the guidance and comments and stuff like that. It's kind of a standalone statement. So the only thing I can think of is if you have a commercial off-the-shelf product that you are buying, the subcontract to purchase that would not have to include the clause, and then that would flow through the system. So I believe that, I don't know why they didn't just say that it didn't apply to COTS. Arguably, it would also apply to commercial products, or really any time where all you are doing is buying a specific product and there's no development, there's no building the product and stuff like this. But that's an area that I think is still very much open as to what they mean by subcontract solely for products. There are some exceptions, but the guidance encourages agencies to apply the clauses under the simplified acquisition threshold as well. So even though the executive order does not specifically excluded contracts under the simplified acquisition threshold, the guidance basically stated that they strongly recommended the agencies include it even in those contracts as well under the FAR deviation subpart. I believe it's 1.4. I think it's listed in one of the subsequent slides. So the next slide. So what is a contract and contract-like instrument? It's a pretty straightforward definition. It's any agreement between two or more parties creating obligations that are enforceable or otherwise recognizable by law. The guidance lists a specific list of items. And one of the things that I found very, very interesting was, and you can read that list there, is it talks specifically about notice of awards. So that means, just reading the straight up language, that if you've submitted a proposal, in the proposal, and there's some timeline things, because obviously if you have a proposal submitted already, the clause can't be in your contract. And since the clause isn't written, it's obviously in the contract. So there's some stuff in the guidance that talks about this interim stage stuff. But say now we're in the November timeframe, right? Your RFP has been revised to add the clause, and you've decided to wait to find out whether or not you won the contract before you're going to implement it. First of all, I'm going to tell you you're too late, because at that point the government's not going to be able to give you a contract at all. But what's interesting about that is by saying notice of awards, that basically means that if they send you a notice of award that you were supposed to have your people vaccinated, you now are required to have them vaccinated. And if you decide that you're going to continue working in the GovCon space, and obviously everyone can decide if they want to get out of the GovCon space at any point in time, so long as you don't have open contracts, you don't have to comply. But once you get that notice of award and you have a current contract and it has not been modified to add this clause in it, the clause now is going to apply to you. And I thought that was kind of very interesting the way they put that in here. The other one is that it's bilateral contract modification. So they've kind of made this clear that the government can't unilaterally apply this to existing contracts. Now, if you get funding, if you get an option renewed, if there's any contract action that occurs, you have a change to your statement of work, anything, that means that the clause will probably come into effect, and there is at least somewhat of an argument that if this were to say happen in the December timeframe, you as a contractor are going to have a problem, because you're not going to be able to be compliant with the law because of how long it actually takes a person to be compliant with getting the vaccine. So who's a covered contractor employee? And this one's even more interesting, because what this one says, there's the obvious one. You work on a government contract, that's fine. You are a covered contractor employee. But what about the person who doesn't work in a government contract? They just work in the same building as the contractor employees who are working in government contracts. Well, they too are considered covered contractor employees, unless the company can make it such that those persons come into zero contact with anyone who is actually working on a government contract. What does that mean? That means elevators. That means lunchrooms. And by the way, it would appear to even include if it's just a lunchroom in your building over which the company has no control. If there's a way to think of this as being as expansive as possible, then think of this as being applicable. Next slide. So where does this all apply? What's the work location? So it's any location a covered contract employee works, and I'm sure there's going to be a question on that in everybody's mind, and we're going to get to that one, especially since a lot of people now work at home. A covered contractor is any prime or subcontractor at any tier who is a party to a covered contract. The covered contractor workplace is any location a covered contractor employee works. We're going to say except their home location, and there's a reason why we have that exception there. And then fully vaccinated means it's 2 weeks after a person's last vaccine. Right now, the vaccines that are acceptable are Pfizer, Moderna, and Johnson & Johnson, and then any of the vaccines that are listed for emergency use by the World Health Organization, such as the AstraZeneca vaccine. Next slide. So everyone must be vaccinated by December 8th, unless there is a medical or deeply held religious belief. And the exception in many ways is very easy. If you have a medical condition that your doctor has told you, and that your doctor is willing to write a letter to your employer saying that there's a medical condition that requires that employee not to get the vaccine. And by the way, it can't just be just those words. It's got to be specific, because keep in mind, the contractors are going to be held to making sure this is done correctly. And if it's not done correctly, the contractors are the ones that are going to be held responsible. So they have an obligation to make sure that the medical reason is a legitimate medical reason. The second reason is the deeply held religious belief. And if anyone had told me 2 weeks ago that I'm basically becoming somewhat of an expert in what's considered a deeply held religious belief, I would have laughed at you. First of all, I'm going to tell you, every single major religion has said that there is no objection to the vaccine, period. And many of the religions have come out and said not only is there no objection to the vaccine, but that they believe it is the moral imperative of their people who follow the religion to get vaccinated to help the general population in the pandemic. If you Google, you'll find there's tons of stuff on this stuff right now, but that's basically what's coming out there. But what this means is that everyone who needs to get vaccinated by December 8th, their last vaccine has to be by November 24th, which is the Wednesday before Thanksgiving. The medical exemptions have to be specific enough to meet the standards of the American Disability Act. Employers can decide on the appropriate reasonable accommodation. Like I said, the deeply held religious belief cannot be based on a personal belief, nor can it be based on philosophical disagreements with getting the vaccine. And I'm starting to see these coming in for one of my clients, and I've got to be honest with you, so far, they all smell. They do not sound like they're deeply held personal beliefs. I am also going to tell you that there are 30 common drugs that the deeply held release is based on the fact that at some point in time, the vaccines were tested with stem cells that have been grown from a line of cells from a fetus that nobody knows if the fetus was aborted or if the fetus was just a natural miscarriage or what, but that seems to be where the objection comes from. However, I'm reasonably certain most people don't recognize the fact that some other most common over-the-counter drugs such as Tylenol, Advil, aspirin, Aleve, Sudafed, Benadryl, Claritin, Delsum, Mucinex, Tums, Maalox. I can keep going on. Apparently, there's a list of over 30 drugs that were in the exact same use in the way that they were used. And so if people are using those drugs, their deeply held religious belief is probably suspect. This is also the area where the state law will have an impact. According to the executive order, this is not an excuse for noncompliance with state laws. You can look online. There is a article/web page that provides a list of every state, whether they provide the exemption for medical, which, as far as I can tell, every state provides a medical exemption for getting a vaccine, and also whether they give, allow a deeply held religious belief as an excuse for not getting a vaccine. I will also tell you that these laws tend to deal with the school vaccines and not adults. But in the case law that very little case law that I have been able to find, the courts have applied the law to the adults by analogy. Next slide. So what do you have to have? You basically have to provide a copy of your vaccine record to the employers. I would strongly recommend every employer keep a copy of the vaccine, not the original, just the digital, that's fine. This is the 4 different places that you can potentially have gotten the vaccine. And at this point, and this is a change, but personal attestations that you have been vaccinated is no longer sufficient. Next slide. So the contractors make sure that all employees and visitors, regardless of vaccination, comply with mask and 6-foot separation guidance from the CDC. And where this comes in is that if you go to the third bullet there, that if you are in an area, and there's actually 4 levels of COVID community transmission rate levels. I've just basically high and low split it between that one. If you're in a high level, then fully vaccinated people must wear masks. If an area goes from low to high, then the mask protocols must be applied immediately. If the area goes from high to low, it must stay low for a period of at least 2 weeks before the mask policy may be lifted. Contractors are also required to have all visitors wear a mask regardless of vaccination status. And contractors must also put up a sign, and then they must also have a contact within their organization that's going to be the coordinator of keeping track of all this applicability. Next slide. So now we're going to talk about some frequently asked questions. And unfortunately, when I submitted the slide deck, I picked and chose the questions that I thought were most appropriate from the guidance, which once again, the frequently asked questions have sometimes been a lot more useful than someone trying to quickly write some policy. But unfortunately, the questions got revised, so I'm just going to verbally tell you when we send out the when we provide the slides to be downloaded, we will change the numbers to respond to the frequently asked questions from the guidance. So first slide, next slide.
All right, I'll read the questions off for you.
I'm sorry?
Oh, do you want me to read the questions or?
Go ahead.
Okay, so the first question is, do contractors have to provide opportunities on site for vaccines?
And the answer to that is no. And in the frequently asked questions, that's going to actually be question 2. Basically, a contractor may provide an opportunity to get the vaccine on their site, but they do not have to, nor do they have to actually provide for specific paid time off. Next slide.
All right, who is responsible for determining a covered employee must be provided an accommodation?
And that's going to be Q4 under the guidance frequently asked questions. So basically, the contractor is responsible for making the determination in accordance with the American Disabilities Act. I will say that the most common accommodation is going to be, if you accept that they're not getting the vaccine, is going to be that they have to wear a mask at all times, that they are in any of the space that your employees work, and that they get weekly tests for COVID, and the contractor does not have to pay for those tests, nor does the contractor have to provide time off for those tests. That can be when done 100%. And by the way, that's regardless of whether it's a medical or whether it's a religious exemption. Next slide.
Do employees who have already had COVID need to be vaccinated?
This is Q5 under the facts. Yes. Basically, it's just because you've had COVID, it's believed you have some immunity, but they're not sure how much immunity is, and so the guidance from CDC is these people should also be vaccinated. Next slide.
Do recent antibody tests that are negative replace getting the vaccine?
No, and there's pretty much nothing else to say about that. Contractors can't accept that. Next.
Does the guidance apply to both inside and outside work locations?
The answer to that is yes. That's Q7. Next.
If a covered contract employee works on just one floor of a building and there are non-covered contract employees working in other areas of the building, do the non-covered contract employees need to be vaccinated?
And the answer to that is yes, unless the non-covered contract employees have a way to be in the building that guarantees no access with covered contractor employees. So if, for example, you're in a building that has 2 elevators and they spill out into 2 different atriums, and you can lock one up for one particular type of customer or employee, and lock it up for a different kind of employee, and they aren't going to meet on the garage. I mean, the description in the clause in the frequently asked question is pretty broad. And some of the things they talk about, no interactions through use of common areas such as lobbies, security clearance areas, elevators, stairwells, meeting rooms, kitchens, dining areas, and parking garages. So it's pretty expansive. So to go one step further, what if you have a campus that has 2 or 3 buildings? Again, unless you can make it such that the people who are not working on a covered contract, a covered contract, can just sitting outside interact with someone who's not working on a covered contract, everybody has to be vaccinated. Next slide.
Does a covered contract employee who works solely from home have to be vaccinated?
This is question 11. They have to be vaccinated, but they don't have to observe the mask and 6-foot distancing while in their home. And this doesn't cover their spouses either. I think that's or their children. So I think that's probably the one area that it did not get overly expanded. Next slide.
Does the guidance apply to subcontractors?
Yes, at all tiers. It provides at all tiers unless they're purchasing a product. And as I said earlier, it's oddly phrased. I'm not sure why they put it in that language as opposed to language that we would normally understand in the FAR. But once the FAR clause comes out, I'm hopeful that the phrase solely purchase product, that they either make it set up so that it makes it clear that it's COTS or that it's commercial products that is being purchased. Keep in mind, if your COTS is a service, it's a commercial service, and COTS is not usually services. But if it's a service, then clearly that subcontract, whether it's commercial or not, is going to be a subcontract that is going to be subject to having the subcontract employees be vaccinated. And that question is question 13 of the guidance. Next question.
Does the guidance apply to small businesses?
The answer to that is yes. This is Q14. It doesn't apply to contracts under the simplified acquisition threshold. However, the guidance strongly recommends that agencies include the draft clause in contracts below. We will see how that happens, but I think agencies are going to be more inclined to include it in everything they purchase, especially in light of the fact that the idea here is to get more people vaccinated than less people vaccinated. So I think the readings are going to be as expansive as possible. Next slide.
What constitutes work performed in connection with a covered contract?
That's question 17. And basically, it's anybody who works, it's your indirect cost pool, shall we say. So it's your human resources, your billing, legal review. They don't mention this here, but I would say your entire executive management staff. I would say anybody who in any way, shape, form, or fashion can be thought of as charging to a contract, whether direct or indirect. Again, keep in mind, overly expansive, not underly expansive. This will cover them. Next slide.
Does the clause apply in states or localities that seek to prohibit compliance?
The answer to that is absolutely yes. That is question 19. Federal law always trumps state law. That was decided in a case called, I think it was Marbury v. Madison, but that could be another case. But it's basically under the Commerce Clause. But in this case, they don't even have to go to the constitutionality of it to make sure that it covers it. Because the deal is, when you sign that contract, that means that you've signed to have this be applicable to you. So let's think about this for a second from the perspective of contracts that are being issued by state organizations. States get money different ways from the federal government. If they get the money as a pure grant, and the grant doesn't include the language, and it's not required to, then the states don't have to flow that into their contracts. However, if the state gets the money through any other interagency transfer or anything else like that, then the guidance is going to be applicable. And when the state issues its state contracts using those funds, they're going to be required to include the clause. That means universities. That means construction contracts. It's going to be a fairly broad brush of this is going to cover. So the only thing, so even in states where they're saying we're not going to mandate, we're not pushing, we're telling our people don't get vaccinated, which baffles me, but okay. If they're getting government funds for pretty much anything, unless it's a pure grant, this is going to apply. Next slide.
Can a covered contractor comply with an OSHA workplace safety requirement in lieu of the clause?
The answer to that is no. We're aware the OSHA guidance has not come out yet, but this actually goes above anything that might come out of OSHA. And it's expressly in here, and that is going to be question 20. So if the OSHA guidance comes out that says you have to get everyone vaccinated, then obviously it's the same guidance. But if the guidance comes out differently, then this will trump that. Having said that, nothing in any of this prevents a contractor or any company from saying, if you want to work for my company, you have to get vaccinated. I will also point out that the courts and the boards, well, the board, I always say the boards, but the courts really aren't where we're looking, the boards aren't where we're looking at in this situation. But all the court cases that have come out on this issue of vaccination have always come out saying companies have the right to require their employees to have certain requirements, and vaccination can be one of them. And that's been in pretty much all the court cases. Next slide. Oh, I am done. I'm going to tell you, a question came in while I was on there, so I'm just going to go ahead and answer it since I do have a second or two. So the question is it recommended that we require employees, contractors, to provide a digital copy of their actual vaccination card? The answer to that is yes. A lot of agencies have a separate certification of vaccination status document that contractors are required to complete and carry with them on site. I'm going to tell you that I do not believe those two things are mutually exclusive. And the certification, the frequently asked question that we talked about earlier about self-attestation, As I was saying at a recent NCMA meeting, that was so last August. Now, what they've done is they're putting the onus on the companies to say that their employees are vaccinated. And I believe what ultimately will happen, and this is just a belief, is that the requirement that you carry some sort of thing saying that you've been vaccinated will go away, because they're now going to go to the companies for the attestation. And with the other executive order that came out the same time as this one applying to contractors, that agency employees must all be vaccinated. It is my belief that if you are a contractor employee working on a government facility, you A, are going to have to be vaccinated, and B, even though you were vaccinated, you still have to wear a mask. But time will tell on that one.
All right, thank you so much, Jody, for a great presentation and sharing your time with us today. And thanks to everyone who joined us as well. You will get a copy of the slides and the recording as well, and they will be posted on our YouTube channel and website. But that is all for us. Thank you for joining us.
Thank you.